continue watching the fight between the European Union and arbitration tribunals. As you might remember, the European Union declared that all the bilateral investment treaties, protecting foreign investors, are denounced within the European Union if they are concluded between two member states of the European Union. And all of them are denounced retrospectively from the day when a particular country became a candidate for accession to the European Union. This is a very exciting and funny fight because, we have a clash of two judicial systems. And my prediction from the very beginning was that, the arbitration tribunals will finally win because, they are a global project, not just a regional one like the European Union. So this year we have already 7 awards of arbitration tribunals where they dismiss this argument that, the bilateral investment treaties were denounced retrospectively. And the reply of the arbitration tribunals is very simple. It merely says that, there is a procedure established to denounce a treaty. You must follow the procedure. It is written how to denounce a treaty. You may not simply step out and say that, you believe that the treaty is denounced. There is a clear, procedure, what you have to do in order to denounce a treaty. And this procedure was not followed by the European Union. So the procedure to denounce a treaty is established either by the very treaty or by the Vienna Convention on the Law of International Treaties. And then the next argument of the arbitration tribunals, for instance, in the case United Utilities, a Dutch company, versus Estonia, is that, well, it might be that the bilateral investment treaties that you have signed provides more rights for foreign investors than for your national investors. But then the most reasonable reaction would be to provide the same rights to your local national investors. Just give them the same rights as you have already given, as you have already provided to your foreign investors. This is an argumentation chain of the arbitration tribunals that I have already described in my previous videos. However, there is a new thing that we observe in the case law of this year. For instance, the case United Utilities versus Estonia. In this case, the arbitration tribunal provides a new argument that I haven't seen before. It says that since the seat of this particular arbitration tribunal is in Switzerland, in Geneva, it means that the Swiss procedural law is applicable to these arbitration proceedings. And then the Swiss procedural law has a huge number of previous judgments that affirm arbitration awards. In other words, the Swiss policy is very pro-arbitration. So this is an additional argument for, rejecting the Achmea case of the European Court of Justice, for dismissing the Achmea case that was, entered by the Court of Justice of the European Union. And I find that this is funny because, it absolutely follows my prediction.